They're over your head.
Gotcha.
Do you see? You're scared now. You're going to be scared later. I'm glad you reacted that way because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. We will go on the record in the matters. 24 TR 718, 24 TR 719, 727, and 922, 23 CF 165, 24 CF 168, 24 CF 240. State of Wisconsin versus Tina Sally. The state appears through District Attorney Kevin Schmidt in person. Ms. Sally appears in person with her counsel, Joseph Rosenthal. We're set today in these matters for pleas and sentencings. Mr. Rosenthal, can you please update the court as to the agreement that has been reached?
Yes, Your Honor, thank you. My client would enter a plea of guilty to an amended count 1 simple possession in 23 CF 165. Counts 2 through 5 would be dismissed and read in. In 24 CF 168, my client would enter a guilty plea to count 2 felony bail jumping. Counts 1 and 3 would be dismissed and read in. 24 CF 240 would be dismissed and read in its entirety. And I believe there is an agreement to dismiss the traffic citations. And both sides would be free to argue. I'm sorry.
What's free to argue? And Mr. Schmidt, I'm gonna guess that, and just correct me if I'm wrong. The reason for the public interest for the amendment from possession with intent methamphetamine down to simple possession of methamphetamine is simply because Ms. Sally was at her place of employment and offered someone else the paraphernalia with the methamphetamine in it to take what I would describe as a hit or to use it. And so that's why it's being amended to simple possession.
If the court wants to know the public interest on it, as the court recalls from the PC statement, also in the police report, this was actually referred as simple possession by St. Croix Tribal. DA Renicky charged it as a possession with intent or delivery. He's technically right. That does constitute delivery for the same reason that a bunch of kids passing around a joint in a school circle, like from that 70s show, that would be delivery as well under Wisconsin law. All laws are overly inclusive or underly inclusive. Therefore, it's up to the judgment of people like myself and you, Judge, and Mr. Rosenthal to figure out, you know, when the laws are overly or underly inclusive, what to do there. There's a situation where she just offered someone drugs. They took it for peer pressure reasons. They didn't use it. They reported it to their supervisor. No money exchanged hands. I don't have any information. Tina's, you know, dealing drugs anywheres. So that's the reason why.
All right, thank you.
And also, Judge, the quantity was like infinitesimally small. I don't even think it was like a 1/10 of a gram. The lab results said like 0.07. So it's just in terms of quantity, you know,
it was very small. The officer wrote in their report it was too small for them to even measure on their scale.
All right. Okay, thank you. Satisfies the court. Formal motion to amend count 1 and 23 CF 165 to simple possession and I felony.
So made.
Granted. All right, Miss Sally, that's the agreement that you've reached with the state. Is that true?
Yes, ma'am.
I have in front of me 2 plea questionnaires, waiver of rights forms. They're identical, except for the charge that you're pleading guilty to and the case numbers. Did your attorney go over, well, and the maximum penalties, they're different too, but as to what those documents state and the form itself, they're identical. Did your attorney go over this form with you thoroughly?
Yes, ma'am.
Did he essentially go over it with you word for word?
Yes, ma'am.
And did you sign both of these documents?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so?
Yes, ma'am.
So you understand everything in these documents?
I do, ma'am.
All right. Now, you were pleading guilty to 1 count of simple possession of methamphetamine and 1 count of felony bail jumping. You're 49 years old. You have 10 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, ma'am.
You do not have a high school diploma or equivalent. However, like I said, you can understand everything that's going on, right?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to these two charges?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalty you're facing?
Yes, ma'am.
You are not receiving treatment for mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours. Is that correct?
Yes, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and those rights are listed on those documents. Next to the rights is a box, and each of those boxes is checked. That tells me your attorney went over those rights with you. You understand those rights, and you understand that you're giving up those rights by pleading guilty. Is that all true?
Yes, ma'am.
You need me to go over those rights with you in any more detail?
No, ma'am.
So you understand those rights completely?
Yes, ma'am, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
You understand that you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
You understand that the state would have to prove in 24 CF 168, the felony bail jump, that on or around July 14, 2024, in Burnett County, Wisconsin, having been charged with a felony in Polk County case number 22 CF 171, and having been released from custody, you intentionally failed to comply with the terms of your bond by possessing illegal drugs, substances, or paraphernalia, and you did not have any valid prescription to possess any of the items you had. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be up to a $10,000 fine, 6 years of incarceration, or both?
Yes, ma'am.
You understand that in 23 CF 165, count 1, amended to simple possession of methamphetamine, and I felony, the state would have to prove on or around September 9th, 2023, you possessed a substance. The substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes, ma'am, I do.
Do you understand that upon conviction, you face up to $10,000 fine, 3.5 years of incarceration, or both?
Yes, ma'am.
You further understand that there is an agreement here for what's called free to argue. Do you understand that means that each side is free to argue any sentence recommendation to the court that they wish and they desire? Do you understand that?
Yes, ma'am.
Do you understand? I'm not bound to follow any of those arguments. I don't have to follow the states. I don't have to listen to the defenses. I must listen, but I don't have to follow, and that I'm free in my own discretion to sentence you to what I believe would be a fair and just sentence for these cases in my discretion only. Do you understand that?
Yes, ma'am.
And that could be the maximum possible penalties. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, ma'am.
Did you go over the criminal complaints in both of those cases with your attorney?
Yes, ma'am.
In particular, there's sections called the probable cause sections that basically say what happened those days and why you were charged with the crimes. For the most part, are those facts accurate?
Yes, ma'am.
Are you admitting here today that on or around September 9th, 2023, you in fact did possess methamphetamine
Yes, ma'am.
and you knew it was methamphetamine?
Yes, ma'am.
Are you admitting here today that on or around July 14th, 2024, that you knew you were on felony bail jump, or you knew you were on felony bail with certain conditions and bond in Polk County on a felony case, and that you intentionally violated that bond and those conditions by possessing illegal substances?
Yes, ma'am.
Mr. Rosenthal, may the court use the probable cause sections along with the statements made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these two charges?
No, ma'am.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing here today
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Yes, ma'am.
Has he looked at these matters thoroughly?
Yes, ma'am.
Has he discussed with you any potential for legal defenses, or has he said you have no defenses or little defenses in this case?
What, I mean,
The question is whether I've advised you
Oh,
on whether there's any
yes, ma'am.
defenses or not.
yes, ma'am.
Talk to you about whether or not you have
Yeah.
any defenses?
Yes, ma'am.
And what, if you go to trial, what could happen?
Yes, ma'am.
Are you satisfied with the services?
Yes, ma'am, I am.
Any questions for the court or your attorney before I proceed?
No, ma'am.
As to 23 CF 165, count 1, simple possession of methamphetamine, and I, felony, how do you wish to plead?
Guilty.
As to 24 CF 168, count 2, felony bail jumping, and H, felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find that you understand and that there is a factual basis. I will dismiss and read in all other counts and cases and open matters. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Sure. Checking one thing. Yep. What I would ask the court to do is sentence to Miss Sally to 2 years probation. Either withheld sentence or a state and imposed sentence. If it does a state and imposed sentence, I think it should be 9 to 12 months on each concurrent. I don't think the conduct merits prison. Normally I'd say 6 months state and imposed, but I do think the giving of the drugs is worse than just possessing it. For conditions, I think the court should order not to possess drugs with or without a prescription or drug paraphernalia, not to have contact with any known users or dealers except as necessary in a treatment or confinement setting, follow rules of supervision, AOD and follow through, and ability to petition for early discharge once all conditions by probation are complete. I'm just reading this straight off of what she was sentenced to in Polk County. I want to mirror the conditions. In Polk County, the basis of the felony bail jump is she was on a deferred agreement for meth and THC. These cases caused that to be revoked. Our cases are meth and THC, so they're really tightly, heavily linked together. So if the court follows what I'm suggesting, it'll just extend her probation by like 2 months, 2 months longer than just the Polk on its own.
Is
But
Polk
if-
withheld?
What?
Is Polk withheld?
They did withheld. I just know the court's preferences for state and imposed, which is why I gave the alternative there. I think she reflects a substance abuse issue. The one condition I would add that Polk doesn't is to get a valid license because of the OAR. Her history is substance abuse. That's what she needs help treatment with. She is obviously capable of being a productive member of society. She was working at A&W when this happened. Thank you.
All right.
And
Mr. Rose, go ahead.
I was just gonna say the Polk case is 22 CF 171 if the court's curious about looking at it.
I'm pulling it up right now.
And obviously ours concurrent to Polk. I meant to say that too, sorry.
Yes. All right. Mr. Rosenthal.
Thank you, Your Honor. We would ask for a slightly less term of probation, 18 months. I do think she's a very good candidate for probation. She's made all her meetings with her agent. She was, at the time of the first case, she was working at A&W. After that, she was working at the poorhouse for a number of months. That's kind of on hold right now. She had a bit of a situation with her significant other that she had to get out of. So, and I think to her credit, she made some healthy choices there. She's, now living up in Minot with her brother. She's informed probation of the change of address. She's informed the clerk of the change of address. Again, this was kind of a situation that was, made, I think it was her kind of being proactive and being healthy and getting out of something that was not particularly, in her best interest. Also to her credit, she stayed in very good contact with me throughout the pendency of these cases. Even just a few days ago, she called me, she said, hey, look, I don't have a ride down to court. I said, hey, Tina, no problem. I'll come and get you. I'm my way from Superior. I'm always willing to go the extra mile for my clients. Again, this is just a reflection on her character of being responsible to both probation and to making sure she shows up to court on time, is not driving without a license, those type of issues. So, again, I agree with the state, she's got a track record of being a productive member of society. I do view this as a rehabilitation case. Again, I mean, we're talking about, a very small quantity here that was already discussed. In terms of it being less than 1/10 of a gram of methamphetamine. The THC, I believe, was a cartridge. So it's, it's personal use, no allegations of, well, there was an allegation, but it's been amended. There's no facts to support, dealing or delivery. So that is, I think, all to her credit. Again, we'd ask for a slightly less term of probation. She's been in compliance, she's had her ups and downs, but, probation's willing to work with her, even with these two cases, they didn't elect to revoke. So I think for those reasons, Judge, we would ask for 18 months with a withheld sentence.
Thank you. Ms. Sally, do you want to provide a statement to the court? You don't have to, but it is your only time to fill me in. Let me know what's going on.
I'm just trying to find a ground to stand on, Your Honor, so that I can get my license back and get back on track. I had to get out of a situation, and I'm starting from the bottom and I'm going back up. I just want to continue to contribute to the society, I mean, I'm not trying to be a problem. I'm not trying to be out there using drugs. I just want to live and be comfortable. I'm sorry about wasting the court's time and all that. I just want to get this done so I can move on.
I appreciate that, Miss Sally. I truly do. I truly do. Everybody says it. I'm going to tell you, everybody says, I'm sorry for wasting the court's time.
I really am, Your Honor.
I want to say it's not a waste of court's time. Cases are not a waste of time. A, it's my job. B, it's the law. And that's why we're here. And when you say it's a waste of court's time, essentially what I hear is, when you're saying it, that you think that you're a waste of time. And I understand that you mean what you did, you shouldn't have done.
That's exactly what I mean, Your Honor.
And I get that. Truly understand, and I get that. Miss Sally, I think this is the first time I've seen you in front of me for things other than driving without a valid driver's license. Quite honestly, if I'm thinking back to 2017 when I first stepped on the bench, my number one objective, well, A, I want you to be clean and sober. I want you down that path. B, I want you to get your driver's license.
I just had it.
You just, yeah, you did.
I lost it because I missed one class.
Why?
I didn't know I had to finish the class. That is honestly my mistake, and I have to start it over, but I'm going to get it done again.
So you got to get it done again.
I'm going to get it done again. I'm already on the path to doing that. I just got to do my AOD again and start over, and it will be done again, all the classes.
And that's a bummer, because then you have to repay the AODA.
Mhm,
You have to
that's
start
all
the
I'm
classes
doing.
Again, 1, 2, 3, and keep going. You have to keep doing
Yes,
that.
ma'am. That's what I'm on right now.
Miss Sally, I have certain things I have to look at when sentencing. One, how serious is the matter? Is this serious? It is. It's methamphetamine. And you were on felony bail and bond from Polk County for similar types of issues and matters, substances, illegal substances. Then I have to look at you individually, Miss Sally, your character, your past criminal record, needs for rehabilitation, those types of things. I know you. I don't know you well. I know you in the context of how you've been here in court throughout these years. I don't think you have a bad bone in your body. I don't think you're out there to hurt people. You're hurting yourself. That's what you're doing. You're hurting yourself.
Can I say one thing, Your Honor?
Yes.
When I was working at A&W, okay, I was standing in the bathroom with the manager and I found something laying on the toilet paper rack and I handed it to the manager. 2 days later, I got arrested for giving her drugs. I had no idea what it was. I didn't know what it was. It was just a little container. I shook it and handed it to her, Your Honor. I had it in my possession for 5 minutes and I just started work there. I'm not gonna go giving my boss drugs. I don't do methamphetamine, okay?
Well, then,
And so I was fighting it.
then if you're telling me that I just took your plea and you admitted to possessing methamphetamine, and you're saying that it really wasn't yours and that it was this innocent thing,
It was in my possession, though.
I get that. I truly understand that part. I understand possession and legal possession. I don't like to take pleas of people who are not really committing the law that they're pleading guilty to.
It was in my possession, so I had
That's
to,
not the facts of the case as they were laid out in the complaint. That's not how it was presented to the court in the criminal complaint or how it was told to the police. It just wasn't.
I told it to the police, but I never got a chance to say anything to anybody.
If I'm remembering correctly, didn't it happen on a break and you offered something?
No,
during the
ma'am.
break?
I was at work online when I got pulled offline 2 days, 3 days later after I had found it in the bathroom and gave it to the manager. I don't even know the manager's name. And I didn't have it on my possession. I just got arrested offline because she said I gave her drugs. She said I gave it to her that day. Your Honor, I didn't give it to her that day. I even went home and told my family about it. But it was in my possession, so I should have got rid of it or threw it away or flushed it or whatever it was, but I gave it to my manager. And because of that, it was in my possession and I gave it to her. So I gave her drugs.
That's all true.
So that's,
All facts. You were in possession, but
And-
it wasn't in. So if I test you here today, you're not gonna test positive for methamphetamine?
no, ma'am.
I need to look at your Polk County case. That's what I need to do.
And I believe she's probably being drug tested anyways, since she's on probation for methamphetamine out of Polk.
Yeah, and see, and there's those allegations of possession of methamphetamine in Polk County as well. And so, Miss Sally, I want to believe you. I truly do. I truly want to believe you. But then we have Polk County case number 22 CF 171, and you pled guilty to possession of methamphetamine, possession of THC. It's a story. It could be plausible. But based upon the facts of the criminal complaint as they're laid out in that criminal complaint, that's not how it happened.
That's fine, Your Honor.
That's not how it happened.
That's fine, Your Honor.
And that's all I get. I don't get discovery. I don't get to talk to witnesses. I don't get to look at anything other than the criminal complaint and information and arguments by both sides.
That's fine, Your Honor. I understand my charges and I'm willing to move forward.
What happened in Polk County then? If you were charged with possession of methamphetamine, you pled guilty.
It was in my possession. So I pled guilty.
You were in possession of methamphetamine
Yes, I was.
on April 21st, 2022 in Polk County.
I
You pled guilty to it, so you must have
I
been
must have been, yes. I pled guilty.
guilty once, guilty twice.
Mhm. I take my charges, Your Honor.
All right. Not candy.
No, ma'am.
You know, can't just like hold it for somebody and then pass it on and not a pen. Miss Sally, I don't know. I don't know what you need because all I know that you've been in front of me for on previous occasions, other than these cases, driver's license. And these other matters are serious. I need to look at protecting the public, and I understand Mr. Schmidt's argument that this is a bit more serious than a simple possession if this is something of delivering or giving to somebody else. And I can't weigh credibility because I don't have the other individual providing me testimony versus your testimony. So I can't weigh any credibility of who's telling the truth with your story or the other story. The police went forward, they interviewed all parties. It's put forth in a police report. The criminal complaint is generated, and that's what's provided to the court. So that's what I have. So probation is necessary and it is appropriate. And your probation started in Polk County, August 6, 2024. And it looks like it was for 2 years, so it'll run through August of 2024, apparently. Mr. Schmidt is asking that you stay on for about 2 years. I don't know what else you can gain for a few more months after your Polk County. Because I'm going to be blunt and I'm going to be straight. Either you're going to follow probation and you're going to do what you need to do and you're going to figure the stuff out, or you're not. And either you're going to do it right away or you're not. It's not usually the last 2 months of probation where people mess up. It's usually right away or sometime in the middle, not the last few months of probation. By then, either they figured it out or they've already been revoked or looking at revocation. Probation is appropriate. I'm going to follow Mr. Rosenthal's recommendation of 18 months of probation, concurrent with Polk counties. With regards to sentences, I understand the delivery argument. I didn't write down what you said. You argued for a year.
I said between 9 months or 12 months because I thought it was more serious than 6 months, but not
Not
a true delivery.
It's definitely not a prison case. Any shape or form, neither of these cases are a prison case. But you should know your penalty and your punishment. You got to figure it out. Even THC, marijuana in the state of Wisconsin is illegal, Miss Sally.
Yes.
You cannot use or possess at all, any way, shape, or form, THC marijuana. You can't. You want to use it? Go on over to Minnesota. They're really close. Move on there. Go to Michigan. Go on there. Go on down to Illinois. Go down there. But you can't stay here. I don't see the law changing anywhere anytime soon in Wisconsin. So with regards to these two cases, I understand Mr. Smith's argument that it is more serious, but I don't believe that you have a severe criminal history, and I've not heard that you have a significant criminal history. There should be a punishment. And again, I can't go off of credibility because I don't have two stories here to determine who's really telling me the truth. So with regards to 22 CF 171 count 1, I'm sentencing you to an imposed and stayed sentence of 6 months of incarceration.
You're not doing
Not
that right
now,
away. That's
not
just imposed
today.
and stayed,
It's hanging
okay?
over your head.
Yeah.
What case number was that?
For both of them, it doesn't matter.
165?
Yep. And for 23 CF 165, 6 months of incarceration imposed and stayed. They're over your head.
Gotcha.
You see, you're scared now. You're going to be scared later. I'm glad you reacted that way because it is a scary thing. 6 months in jail.
Yeah, I don't want to spend 6 months in jail.
Figure it out. Miss Sally, figure it out.
I'm working on it, Your Honor. I really am. I got out of a situation and I'm on a roll.
And I'm glad. And this means no disrespect at all. I mean, no disrespect when I say this.
Mhm.
It looks like you've put on a little bit of weight.
I have,
That's a positive thing.
thank you.
That's a good thing. That tells me you are now taking better care of yourself.
I am, Your Honor, thank you.
So that's why I say no disrespect. Women usually don't like to hear that they've gained weight, but this is a positive thing.
Thank you, Your Honor. I didn't think anybody noticed.
So while on probation, no use or possession of any illegal drugs, substances, or paraphernalia. No bars, taverns, liquor stores, casinos, or establishments that have the primary purpose for the sale or the service of alcohol, except for work-related matters.
Got you.
AODA assessment and follow-through, get your driver's license, regular testing, no use or possession of a firearm for life, no voting in any election until your civil rights are restored, no alcohol. I'm going to also say no contact with anyone on felony probation or felony extended supervision for drug-related charges and convictions without agent approval, except in treatment or if you're incarcerated, obviously. $443 and no, $518 in fines and fees per count. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. Civil judgment, if you fail to pay, you're always going to owe it. If you don't pay, I'll issue a warrant. You could sit up to 6 months in jail. I'm very harsh. You should know that. I follow who pays and who doesn't.
I know.
People sit in jail if they don't pay. I need your DNA. When you're done here, you're going to go and provide it to the sheriff's department. You have the ability to request it be expunged through the written letter through the Department of Justice. Not me, not the county, the Department of Justice. It looks like I need fingerprints in 24 CF 168. You're also going to need to give fingerprints in that file. I need them in every file. What am I missing, Mr. Schmidt?
One, did the court say get a license as one of the conditions?
I did.
Mhm.
And two, because Attorney Rosenthal expressed uncertainty about the beginning, we are dismissing, but reading in all the traffic tickets, including the Village of Siren ones. I have authority to do that from Adam Benson.
Yes, everything else that's open.
Okay.
What am I missing?
I may have missed it, Judge, but was there concurrent language on both counts if revoked?
Yes.
Okay.
Current.
Okay.
All right. Then we are adjourned. Thank you.
I'm going downstairs.
I gotta.
Yeah, you gotta get some paperwork.
Yeah. I gotta run downstairs.
All right. Don Joyce, the individual from Mr. Meyer, can you hear me? And can you put me on video and unmute, please? Meyert, Mr. Meyert. Are you there, Mr. Meyert? Palo Alto, Iowa Jail? There
Yep,
we
we're
go.
here. Okay.
Thank you.
Can you hear us or not?
I can definitely hear you. Thank you so
Okay.
much.
Let me grab him real quick here.
Can you hear me, Mr. Mayor?
Yes,
Meyert?
Your Honor. Yes.
How do you say it? Mayert or Meyert?
Mayert.
Mayert, thank you. We will go on the record in the matter 26 CF 79, State of Wisconsin versus Christopher Mayert. The state appears through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel, in person. Mr. Mayert appears by video conferencing in custody at the Palo Alto, Iowa jail. We're set here today for an initial appearance. Mr. Feliski, were you able to go over the criminal complaint with Mr. Mayert?
Thank you, Your Honor. I did have an opportunity to discuss the complaint here with Ms. Mayert, excuse me. I would note that she does go by, from my recollection, she, her pronouns. I had an opportunity to review that complaint with her. I believe she does understand the charges here, the maximum penalties. We will waive formal reading to any misdemeanor counts, enter in pleas not guilty, and would request a preliminary hearing outside of time limits at this time.
All right, not guilty plea will be entered for the misdemeanor. We'll set a preliminary hearing. May I call you Chris?
Yes.
Chris, how long are you going to be in Palo Alto?
I'm actually going to be going to prison here for at least a 5-year sentence. So it might be a 10-year. They're working that out.
Well, you'll wait and see on that. So we're going to try and get this one figured out as quickly as possible, I'm thinking then.
Yeah, I don't know how this process works over there. I mean, my stuff is
Yep.
mostly, yeah.
Yep, I'm just trying to get an idea of if you're still going to be in that jail in the next couple of weeks.
Probably. I mean, yeah, they think so.
Excellent, okay. And is there a time, it looks like you have a deputy or some other law enforcement person with you that may be managing the jail, and who can use Zoom and when? Can you see if there's a time that works best for us to have a hearing with you? If it's like a 9 o'clock, a 10 o'clock or whatnot, or is there any time to avoid setting a hearing?
I'd say afternoon is best, but he's right here.
9 o'clock's not bad. Anything after 1 o'clock is better. We're a single jail department, so.
All right, and I can accommodate afternoons. If you tell me afternoons are best, I will stick
Yeah.
with afternoons.
Okay.
And so what is the time where you are right now?
It's a little after 1, like 1:10.
Okay, so we're
Yeah.
on the same time zone. Just wanted to make sure.
Yeah.
I could do 2:45 on August 26th.
Okay.
And I'm just going to ask this just because I'm required to. Chris, are you okay with appearing by video conferencing?
Yes.
Okay, all right. And so if this is going to be a preliminary hearing and not a waiver, because Chris is requesting to appear by video, it would just be a stipulation to identity. You can discuss that with Chris, correct?
Correct, Your Honor.
All right, thank you. Chris, your attorney will be in contact with you, but we do have you scheduled for 2:45 on August 26th.
Okay, thank you.
All right, thank you. I see an attorney that I am not familiar with, so I am just gonna swap you on out.
Of course, Your Honor.
Benjamin Jansen and Mr. Whitaker.
Case number 26, CMN 1.
We will go on the record in the matter 26 CM 104, State of Wisconsin versus Quinn Whitaker. The state appears through District Attorney Kevin Schmidt in person. Mr. Whitaker appears in person with counsel Benjamin Jansen. We're set today in this matter for an initial appearance. Is this a case that an offer could be presented at this time?
One sec, our system's been slow since noon too.
I believe this involved just lighting fireworks.
The offer we intended to make on this would be a 6 months deferred judgment and conviction on the DC.
All right. So Mr. Whitaker, what he is saying, and your attorney can go over that with you, what it means, as you said, a 6-month deferred judgment, like judgment of conviction. That's what you're asking for?
Yes.
Okay. That is an agreement, a contract. If you plead guilty to the crime, it'd be held over your head for 6 months. You'd have to pay an administrative fee of $150, not have any other crimes or not have any conduct that rises to probable cause for a crime. Pretty much that. It wouldn't need any AODA, none of those types of things. Pretty simple. If you complete all of that within 6 months, it gets dismissed, it's gone. So you can talk to Mr. Jansen about that, about if you wish to accept that offer. If he does, Mr. Jansen, the court can take care of it as in a quicker fashion. And if Mr. Whitaker is okay with that, as long as the court has the signed document before the hearing, you may appear by video conferencing, save time, save money. But if you wish to have him in person, great too. So I can set a status out, Mr. Jansen. How far out would you like to have the status? But first, I guess he understands the charge and that maximum penalty.
He does, Your Honor.
Waives formal reading.
Yes.
Not guilty plea will be entered on your behalf. So how far out would you like the status, Mr. Jansen?
It really depends on the state. We haven't received discovery yet. 2 weeks after for a proper discovery review, and then a discussion with my client should be just fine.
They're very quick on getting discovery, and it's by a link. I don't know how you do it. I think you're from Minnesota. Are
No,
you-
I work at Door Drill and Scout in
Oh, do
Richmond.
you? Oh, I didn't recognize, sorry. Yes, so that's right. Okay. So yeah, if you haven't worked with the district attorney here before, it's relatively quick and it's still through that little link.
If that's the firm, they probably already have an account to get it.
Okay, so then it should be relatively easy. So I could do August 27th if you want it early, or I can push it out further.
August 27th should be fine with me, Your Honor.
I can do August 27th at 9:45 if that works. And if by chance you look at all the discovery, you speak with Mr. Whitaker and he wishes to accept that offer, we could handle it that day and take care of it.
Sounds good.
All right, anything further?
No, Your
Nothing for
Honor.
me, Your Honor.
Thank you. We are adjourned. Mr. Hammond?
I can get you your notice. You want your notice of hearing?
Mr. Whitaker, Quinn Whitaker, that just has a notice of your next hearing date and time. We'll go on the record in the matter 26 CM 103, State of Wisconsin versus Matthew Hammond. The state appears through District Attorney Kevin Schmidt in person. We have Amber Sherwood, Defense Counsel in person with Mr. Hammond. We're set today for a status conference. I believe this is a correlating case. Is the offer the same?
Yes, Your Honor.
The same offer. Would you like me to explain it to you as I did with Mr. Whitaker, or were you here, or were you listening and you can speak with Ms. Sherwood?
Sorry, I was
Oh,
doing something. I did not hear it, Your Honor.
it's a deferred judgment of conviction for 6 months, no special conditions, just not engaging in any conduct that rises to probable cause. And then the matter would be dismissed off his record.
Okay. Can I
So-
have one moment to speak with him so he knows, or can we set?
We're gonna set it out, but you did go over the criminal complaint with him?
I have, Your Honor, gone over the maximum possible penalties. We waived the formal reading and plead not guilty.
That guilty plea will be entered on your behalf. You are entitled to a jury trial, would be entitled to a speedy trial, should you request one. I can schedule you for 10 o'clock on August 27th. I know that's a short turnaround, Miss Sherwood. However, I did set the other individual for 9:45. I'm not sure if they need to be around the same time, but if once you get discovery, you discuss it with Mr. Hammond. If he wishes to accept that offer, I can take care of it and get the matter done that day.
Perfect. That time works for me. Does that work for you? That works for the defense.
All right, thank you.
Thank you.
Mr. Campo,
Would you like your,
sir, Mr. Hammond, there's it'll give you your date and time.
That's yours.
We will go on the record in the matters 26 CF 99, 26 TR 432, State of Wisconsin versus Brandon Campo. There may even be another one. Yes, 26 TR 637. The state appears through District Attorney Kevin Schmidt in person. Mr. Campo appears in person with his counsel, Joel Feliski. We're set here today in this matter for initial appearances and intakes. Were you able to go over the criminal complaint with Mr. Campo?
Yes, Your Honor, I did receive and review the criminal complaint in this case with Mr. Campo. I believe he does understand the charges and the maximum penalties. We will waive formal reading to any misdemeanor counts, enter in a plea of not guilty, and would request a preliminary hearing outside of time limits.
All right, not guilty pleas will be entered on your behalf. On all matters, you are entitled to a jury trial, would be, well, we'll get there. We're doing a prelim first. I appreciate your dress here today, Mr. Campo. You always look professional. All right. Always, it made you seem like you're here all the time. The other time I saw you, you look professional as well. Okay, outside of time limits. I could do August 31st. August 31st at 3:30. You're already coming for a prelim. I can set it then, at which time, Mr. Schmidt, I will put this on over to Mr. Vila's calendar.
That time will work.
All right. You can come get your note. Well, let's do bond. The court will reinstate bond, not with the cash portion, but reinstate it as $1,000 signature bond, same conditions as previous, okay?
Okay.
So you're gonna have to come up here before you leave, sign bond, and you're free to go.
Okay.
All right, do you have a question?
No.
Okay. Is that your last case?
Your Honor, I'm here to make a special appearance for Matthew Olson Jr.
All righty. All right, Mr. Campo, you can come and get your documents and you're free, well, to sign, and then you're free to go. Matthew Olson Jr.
can email you a copy of this? Copy machine does not work. Sign where that little pink dot is. Thank you. There's your notice of hearing there.
We will go on the record in the matter 26 CM 89, State of Wisconsin versus Matthew Olson Jr. The state appears through District Attorney Kevin Schmidt in person. Mr. Olson appears in person with counsel Joel Feliski, making a special appearance on his behalf here today. We're set for an initial appearance. Before we even go down that road, is there an offer that can be presented?
The offer in this case would be an ordinance for possession of THC, dismissing but reading in the paraphernalia.
All right, so Mr. Olson, what that means is, if you don't understand, is the state is offering you to amend the crime of possession of THC down to an ordinance violation, like a ticket, all right, and to dismiss that other crime. So that is an offer. If you would like to accept the offer, and I'll give you time to speak with Mr. Felisky, we can take care of that here today.
I'd like to speak to an attorney more about that.
He did speak to me prior to this, Your Honor. He applied, but was not eligible due to income. I did provide him with the court-appointed application.
Would you be able to answer questions as making a special appearance about the ordinance offer?
I did discuss the possibility of that offer with him, Your Honor, and my understanding from that conversation, he would still like to consult with counsel first.
Okay, so you need a court-appointed attorney, or you're gonna ask for one?
Yes, Your Honor. I have the application in my pocket for that.
You must fill it out before you leave here today.
Okay.
Where do you work?
At Kaywood Trust Company or
Wood?
Inc.
Mhm.
in Fallen,
And how much do you make an hour?
2150.
And you work full-time?
Yep. Yes.
Okay, what I'm going to need is $300 down before an attorney can be appointed to you, and it will be $50 a month that you have to pay towards the cost for the attorney, okay?
Okay.
So how soon would you be able to put $300 down?
I can do that on Friday, Your Honor.
Friday, the 14th?
Yep.
Okay, by 4 o'clock, are you able to do that?
I get off work at 3:30, so
So-
4:30.
4:30, they close at 4:30, so you have to be here a little bit before.
Okay, yeah.
4:30. So they won't be able to take it, but before end of business this Friday, put $300 down. And so he understands the charges and the maximum penalties,
I believe so, Your Honor.
Yes, Your Honor.
and not guilty pleas will be entered. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I can schedule you. Once you pay the $300, I can appoint Daniel Chapman and give you a date of September 10th at 9. Oh, wait, wrong case. Sorry, it's a VLAW case. September 28th at 10:30.
That'll work, Your Honor.
Okay, September 28th at 10:30. And once you have the $300 down, then my assistant will appoint Daniel Chapman to the case. And you'll get an order with his contact information, and then you can give him a call and talk to him about the case.
Okay. Thank you, Your Honor.
You're welcome. You can come up here and get the notice. Please make sure you fill up that application before you leave.
I will. Thank you.
Miss Frazee, Jennifer Frazee.
Yeah, of course.
We will go on the record in the matter 26 CF 105, State of Wisconsin versus Jennifer Frazee. The state appears through District Attorney Kevin Schmidt in person. Ms. Frazee appears in person without counsel. We're set here today in this matter for an initial appearance. Ms. Frazee, you're here without counsel. Were you going to apply for a public defender?
Yeah, I just been having some troubles and hadn't had time to.
Well, I don't know where Mr. Felisky went, because you could have spoken with that gentleman to see if you qualify for a public defender. Oh, I didn't see you back there. You can do it.
I have 3 cases in front of you.
3 cases. If you can find Mr. Felisky, thank you.
Of course.
All right, so you'll meet with the gentleman that will come in here. You'll go meet with him to see if you qualify for a public defender. If you do, they'll appoint one to you. If you don't qualify, then we'll go over court-appointed the court-appointed process, okay? So I'm going to briefly adjourn your hearing. I'll call you back as soon as you're done speaking with Mr. Felisky, and then we'll go from there, okay?
Okay.
Do you have her complaint?
Here you go, man.
Yep, show that to Mr. Felisky, okay?
I'm not sure where it
Drake Herman, is he in custody? All right, Ms. Sherwood, who would you like? I just called Drake Herman, but I don't have him here.
I have no information for the court.
All right, so we'll just call his case first. We will go on the record in the matter 26 CM 93, State of Wisconsin versus Drake Herman. The state appears through District Attorney Kevin Schmidt in person. Mr. Herman fails to appear. His counsel, Amber Sherwood, appears in person. We're set for an initial appearance. Mr. Herman was provided a ticket for this case with a mandatory appearance date of August 12th at 1 o'clock. He was provided that ticket. Then he was later summoned by the district attorney's office to be here this date and this time. And we have that he was actually served this in person, to his person, and he fails to appear. What is the state requesting?
I stand mute.
Oh, you represented him, that's right. Okay, stand mute. So what the court is going to do is issue a warrant, $250 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned.
Thank you.
Mr. Kincaid? We will go on the record in the matter 26 CF 81, State of Wisconsin versus Brandon Kincaid. The state appears through District Attorney Kevin Schmidt in person. Mr. Kincaid appears in person with counsel Amber Sherwood. We're set today in this matter for a return on warrant. Warrant has been quashed in an initial appearance. Ms. Sherwood, were you able to go over the criminal complaint with Mr. Kincaid?
I was, Your Honor. We also went over the maximum possible penalties. We waived the formal reading, plead not guilty on the misdemeanor charges. We asked for a preliminary hearing, but waived time limits.
Not guilty on the misdemeanors. The court will set prelim September 3rd, 1 o'clock.
That was for the defense.
Okay, so September 3rd at 1 o'clock. All right, you can come get your notice and you're free to leave, except let me verify, are you still on Valley Boulevard?
Rich Valley Boulevard?
Oh, Rich Valley Boulevard. And telephone ends in 2256?
Yep.
May we send you text message notifications?
Yes.
Okay. If I see you're coming from a distance, if this is going to be a waiver of a hearing, your attorney will explain all that to you. If it's a waiver, he can appear by video or by telephone, as long as he has service. So he doesn't have to make the huge trip.
Thank you.
All right, you can come up here and get your notice and you're free to leave.
Thank you.
We have Misty Kirk.
Just giving you the Zoom information.
We will go on the record in the matter 26 CF 58, State of Wisconsin versus Misty Kirk. The state appears through District Attorney Kevin Schmidt in person. Misty Kirk appears in person with counsel Amber Sherwood. We're set here today in this matter for an initial appearance. Ms. Sherwood, were you able to go over the criminal complaint with Ms. Kirk?
I was, Your Honor. We went over the maximum possible penalties. We waived the formal reading. We asked for prelim waiving time limits. We expect this may be a waiver. May she appear via Zoom? Should it be a waiver, Your Honor?
All right, let me just see. I'm seeing in my case file, she has prepaid the restitution
Yes.
and she has a $500 cash bail in the matter. Okay, so this is one that will need a prelim, Mr. Schmidt. I guess it's a Mr. Vila case. You do 115 September 3rd.
Thank you, Your Honor.
All right, you can come get your notice and you're free to leave. Yes, if it is a waiver, she may appear by video or telephone. Well, she's in Siren, so she can be here in person. All right, thank you. You can come get your notice. Do you have any others?
Nope. That's all mine for you. Thank you.
Hornsby? Alberta Martin? That's all I have.
The other one, the name.
You're
Plead not guilty, waive formal reading, and would request a preliminary hearing outside of time limits.
guilty pleas on the misdemeanors. We'll set a preliminary hearing. 115 on September 3rd.
In the event I'm appointed, that time will work.
All right, otherwise, FYI, Ms. Sherwood's coming back for prelims that time too, so.
Of course.
All right, thank you. You can come get your notice and you're free to leave. Ms. Llewellyn,
Yes.
have you had an opportunity to speak with the public defender?
No.
Would you like an opportunity to do so?
No, my mother said she is dropping the charges.
Well, she has a say, I guess, input, but the district attorney is the one that makes that decision. Mr. Schmidt, this is Felicia Llewellyn. Is Vicky not in today?
She's in today.
We have to wait until 2 o'clock before we call it.
That would probably be safe.
All right. Ms. Llewellyn, I can't call your case until 2 o'clock, but then I will call yours first, okay?
Okay.
You scored.
What's that? What am I saying about that thing? Is the biggest liar in the world. She does it for a living. Oh, she's ever done. Everywhere she
Ms.
goes.
Llewellyn?
Yes, ma'am.
All righty. Just give me 1 second. We will go on the record in the matter 26 CM 105, State of Wisconsin versus Felicia Llewellyn. The state appears through District Attorney Kevin Schmidt in person. Ms. Llewellyn appears by video conferencing with approval of the court, as she is a resident of Oklahoma and she had returned from Wisconsin to Oklahoma. She's here without counsel. The counsel in Collins in jail. I inquired about whether or not she wanted to speak with the public defender. She did not at this time. She's here without counsel. Before we proceed, we are in victims' rights compliance. Is there an offer that can be presented or normal course?
The two offers we'd make in this case would be either a DJOC involving 6 months resulting in dismissal, or an ordinance for DC.
Okay, so Ms. Llewellyn, you can take your camera off because it looks like your bandwidth is kind of reaching its limit there. So you can have your camera off, so that might help with your connection a little bit better.
Okay.
I think, there you go. So Ms. Llewellyn, the district attorney here, you've been charged with disorderly conduct. Whereas the district attorney has stated that on or around July 10, 2026 in Burnett County, Wisconsin, while in a private place, you engaged in violent, abusive, or otherwise disorderly conduct, which under the circumstances tended to provoke a disturbance. That is a Class B misdemeanor. Upon conviction, you could be fined $1,000 up to $1,000 or imprisoned up to 90 days or both. The district attorney has made an offer to you to resolve this matter. It could be resolved and taken care of here today. It's a your choice offer, basically, to be handled today. He has offered that he would amend it or ask the court to amend it to a ticket, an ordinance violation, a ticket with a fine. And that could resolve the matter here today, and it would no longer be a crime. Or you can accept an offer. He's made a second part offer that if you don't want the ticket, that you can plead to the charge of disorderly conduct and enter into an agreement, whereas it'll hang over your head for 6 months. But if you don't get into any more trouble, then the matter will be dismissed completely. So do you understand those two offers?
Yes.
Do you wish to accept either one of those offers?
How much is the ticket?
The
Do I have to
ticket
pay
would
it
be
today?
the ticket would be $500. You have the cash already posted. You'd get money back.
Okay. Then I'd probably rather pay the ticket.
All right.
Because so I would get my bail back.
Yes.
Yes, thank you.
Formal motion to amend to an ordinance violation.
So made, and we are in victim rights compliance because we specifically talked with the defendant's mother about this outcome.
Thank you. It is granted. The court will assess $500. Well, first, do you wish to enter no contest plea or a guilty plea?
No, not guilty.
No contest plea will be entered on your behalf. The court will assess $500. You will get the remaining amount of bail that you posted. It'll be mailed back to you if you are the one who posted it. Are you still on East 1027 Road? And I did not give your numbers on purpose. Is that your address?
No, and I don't have an active address. They can't just put it back into my account that they took it out of?
They can't do that.
I don't have an address right now. I just moved back. I don't have an address right now.
Do you have a friend or someone that we can do in care of and send it?
No. Is there? No, I don't know. Is there any way I can get back to you and give you an address to send it? I'll have to go get a mailbox.
That's totally fine. Totally fine. Why don't you do that? This matter's taken care of here today. You're done. And then why don't you give the clerk a call, the court clerk a call, and you can tell her this situation, and you can tell her when you'd be able to give her an address to send the money back to, okay?
Thank you.
All right, thank you. We're adjourned, and yes, I'll put you into a breakout session, Mr. Chapman.
Thank you, Judge.
We will go on the record in the.
Okay, Zoom needs to be.
It's you, Mr. Chapman. I have to remove you. There, much better.
I thought I closed it.
We will go on the record in the matter 26 CM 81 State of Wisconsin versus Colin Daniels. The state appears through District Attorney Kevin Schmidt in person. Daniel Chapman appears in person as counsel. We have Colin Daniels appearing by video conferencing in custody in Burnett County Jail. Has an offer been presented, Mr. Schmidt?
It has, Your Honor.
Okay, and is it something that is being considered?
It definitely would be, except it involves Mr. Daniels getting some stuff done prior to the plea, which he can't do from jail. So I'm going to talk to Mr. Schmidt about other options. Otherwise, he should have a sentencing after revocation coming up pretty quickly, and I can't imagine he's going to sit too much longer for a misdemeanor.
Yeah.
So he can do it after he gets out, in
I
theory.
can fit it in relatively quickly.
I am not his lawyer for that case.
Oh, you're not?
No, I'm not. I don't know if I had a conflict on that or his other attorney had a conflict on my case, but for some reason it was assigned to two different lawyers.
What case number is that? Is it that the fleeing matter?
Yeah.
Oh, I see just you on the case. 25 CF 55.
Attorney White.
What?
It's Attorney White. He was appointed for the revocation, so he will then come in for the sentencing after revocation.
Oh, okay. Why do I say Dan? It says Daniel Chapman.
It's probably because I never opted out of CCAP after closing on the original matter, and there's nothing for Attorney White to opt into because it's just an administrative case at this point. But I'm sure he will be opting in for the sentencing hearing or calling you to schedule it. Did you privately hire Mr. White, Mr. Daniels?
Yeah, my dad had hired him for me because I was in jail. I couldn't get a hold of anyone.
Thank you. That explains it, Judge.
I'll just be a minute. I can schedule you. Mr. White is coming. Excuse me. August 25th at 10 for a different matter, and he will be in person. Need to look at that date.
I have two status conferences in Sawyer County at 9:45. I could make arrangements to appear for those by Zoom.
You can Zoom in. Yours is probably just going to be a status, but at that 10 o'clock, I'll have Mary reach out. I can probably do a sentencing double book work because Mr. White's supposed to be here for 2 hours that day. And I don't think I need 2 hours for that one hearing.
Okay, that would be fine then.
So let's do 10 o'clock. August 25th, yes.
And if we resolve them both together, I will do my best to be here in person at that time as well.
Okay, sounds good.
What time on the 25th?
10 o'clock. We do have the Stewart competency hearing. However, I don't believe we need 2 hours for it.
I'm going to be cross-examining witnesses and perhaps bring a third.
So we might.
Yeah, sorry.
Well, let's do it at 10 anyway. We could probably even, there are 2 misdemeanors, perhaps. What would, well, he wouldn't be able to get them resolved unless you talk about a different offer.
Which I will.
Okay,
Otherwise, he can do the things Mr. Schmidt is asking him to do after he's done serving his sentence on the revocation and gets out again.
I don't anticipate sentencing on that other case will take long. Like you said, he's been in custody already for a long time. Okay, thank you. We are adjourned.
Thank you, Judge. Mr. Daniels, give me a call if you have any questions, okay?
Alrighty, thanks.
Thank you.
Is that all on June 15? Oh, yeah. Mr. Meister, not here yet. Could you also, for me, please? Well, no, I'll have Mary do it. Never mind. I was just gonna say schedule the 25 CF55 Colin Daniels at that same time, 10 o'clock on the 25th. Have Mary send him a confirmation email. Yes.
How long you have to set that?
15. There's a bunch of people outside. Oh, they're just talking to Chapman.
This courtroom hearing became deeply emotional when Cindy Patra appeared for a plea and sentencing on an OWI 5 or 6 felony. Cindy entered a guilty plea, and the judge carefully explained exactly what she was giving up, including her right to a trial, the right to cross-examine witnesses, and other constitutional protections. Because this was a felony conviction, the judge also explained the serious consequences involving firearm possession and voting rights. But what happened next completely changed the atmosphere in the courtroom. Around 10 people had come to support Cindy. The judge noticed the crowd and specifically recognized how unusual it was to see so many people standing behind someone at sentencing. One by one, her co-workers, friends, and community members described a very different side of Cindy. They talked about her helping people in difficult situations, raising money for co-workers facing medical problems, stepping in at work whenever she was needed, and continuing to contribute to her community. One employer described her as dedicated, dependable, and someone he believed was needed by both the workplace and the community. Then